India Law Foundation. According to the Asia Law Profiles, the high-profile advocate and litigator Lalit Bhasin sir and Bhasin and Company Advocate continues to be one of the New Delhi's leading litigation firms. Apart from litigation, the firm also has a very reputation for its general corporate and commercial work and has recently joined the list of firms involved in privatization. We welcome you, sir. Before moving on, let me lay down the protocol of the session. Everyone is requested to keep their cameras on throughout the session. Everyone is requested to keep their microphones on the mute mode unless you've been asked to unmute specifically. Everyone is requested to maintain the decorum of the session. With this, I would now like to invite Mr. Lalit Bhasin for an introductory address on mechanism of appeal in investment arbitration and role of national court in investment arbitration, a general overview. Thank you, sir.
Thank you, Nikita. My greetings to Professor Dr. Hober, one of the most eminent law practitioners and a jurist in the field of arbitration and dispute resolution. Professor Dr. Purvi Pokhriyal. She is not only a professor and dean of the Institute of Law, but over the years we have become good friends also. And of course, the young organizers and the moderators, Nikita and Taruna, and the faculty members who were named by Professor Pokhriyal for putting in place this very important and significant event. I also bring greetings to the student participations from the Bar Association of India. I think, Nikita, you may update your the profile which you have of me. I have been the president of the Bar Association of India, and I'm the chairman of the Chartered Institute of Arbitrators, India branch. I bring to you greetings from Bar Association of India and the Society of Indian Law Firms, and also from the Chartered Institute of Arbitrators, the India branch. Firstly, I must congratulate the Nirma University and the law school under the leadership of Professor Purvi Pokhriyal for organizing this event, which primarily focuses upon the branch of law relating to dispute resolution in the course of it and the implementation. This has tremendous economic impact and thereby requires constant innovations to stimulate the much needed investment for the expansion of our economy. It's indeed a great pleasure to be here and to associate myself with this unique event. It is focused on the kaleidoscope as also on investment, state investment. So we have Professor Hober, who is an expert in this branch. So I will leave that part to him. And I would generally give an overview of the arbitration in India. How has it fared? Whether it has fared well, whether it has taken off, or still it is in the process of improvements after so many amendments have been made. The subject, you see, reminds me of James Forrestal, who said that, I quote him, "The only way in which a durable peace can be created is by worldwide restoration of economic activity and commerce." This is what he said. At such an important juncture, it would be wholly fallacious if we ignore India's emergence as the world's most potent economic power. Indian market is the place where every big brand yearns to have its footprints. Every marketeer wants space in the Indian market, which is on the verge of realizing its full potential of leading global economy. The reforms that began in the 1990s catalyzed unprecedented growth rates which have been driven by a large and young workforce, as a result of which India has finally earned a place among world's leading emerging markets. Our country has come a long way from decades of stalled economic growth to become an economic destination that is witnessing increased capital inflow and foreign investment. Indian economy has emerged in the last few years as one of the most attractive destinations for the foreign direct investment. Therefore, the time has come now. And as Victor Hugo had said, no force on earth can stop an idea whose time has come. So, India's time has come now. The time for India to lead march of global economic resurgence has come, and there is no stopping it. Well, having said these laudable things and laudable goals, are there any impediments? Are there any roadblocks you see so far as the economic growth and inviting the investment from foreign countries is concerned? Yes, there are many impediments, and it would be unrealistic if we don't discuss those. And one of the main impediment is the dispute resolution part, where you see we have miserably failed. Our litigation has virtually broken down. Our system of the administration of justice, it needs a complete overhauling. Well, there are many reasons, you see. Actually, we are not accustomed to this adversarial system of dispute resolution. This was not the Indian culture. This was handed over to us by the British because England, you see, is a small country as compared to India, but a rich country at that point of time. It could afford a 3-4 tier system of first you go to the lowest court, then you go up in appeal, then you go up in revision, then eventually everything you see goes to the House of Lords and all that. They could afford that. In India, we had the original panchayat system where the disputes used to be resolved straight away. Actually, it never culminated into a dispute. There were only differences amongst the parties which were resolved mutually by a consensual form of delivery of justice. And from village panchayats, this was taken up to the Zilla Parishad, the district level, where again the same sort of resolution used to take place of the disputes. In India, we have too many laws. We have outdated laws. We have lopsided laws. And we have most ill-drafted laws. These are good for lawyers. You see, they can thrive by this confusion in the laws, by so many laws being in place, because that requires so many regulators. So many decisions are given by the regulators. Those decisions are challenged. But is it good for the country as a whole? For the economic development? Does it inspire confidence in an investor? And particularly where the government is involved, where the state is involved. I would give you 2-3 examples where government of India has been a party. under the bilateral investment treaties with various countries. And most of you must have heard about the famous or notorious Vodafone case. It depends which side you are on. You may call it a famous case if you want, you see, to side with the Vodafone's contention, or you can call it a notorious case if you support the government of India. But as a law student and as a lawyer, which I am, I feel, you see, that the government stand was not supportable at all. Same thing happened, you see, in the case of uh, Devas Mauritius Limited, Telecom Ventures, and Devas Employees Mauritius Private Limited, in a 1.45 billion ancestral arbitration claim against the Republic of India brought pursuant to the Mauritius India BIT. Following a successful hearing in 2016, a permanent court of arbitration tribunal in The Hague issued a merits award holding that India's actions in annulling a contract between Devas and Antrix Corporation and denying Devas commercial use of S-band spectrum constituted an expropriation and denial of fair and equitable treatment in breach of claimants' treaty rights. The courts of The Hague have upheld this award. And this was against, you see, the government of India. And the government of India has not taken kindly to this award, although the award is fully justified. Another one was the multi-billion dollar investment treaty dispute against Republic of India relating to Indian tax authorities attempts to levy and enforce royalties tax on software provided in India. And if you have read today's newspapers, I think this issue finally has been decided by the Honorable Supreme Court of India that these are not royalties, payments made to entities outside India which provide software to Indian companies. They are not in the nature of royalty. Therefore, these are not taxable so far as India is concerned. So this is finally the apex court had to intervene, you see, in this. So I gave these examples to show that government also has to change its mindset, particularly government of India. The bilateral treaties are very sacred. They are sanctified, you see, by the two governments who enter into this agreement. It's a solemn agreement. They should be implemented, understood, and enforced, you see, in letter as well as in spirit. Then this is a word of advice, you see, to the government of India as to how they should treat these BIT disputes. It's not a question of ego. Very well, if you have lost it before the arbitrators, fine, accept the award. That is what the arbitration is meant for. Unless the award is, as Supreme Court says, unconscionable, you see, or it is now the fraud also has been brought in only on grounds of fraud and all that you can challenge. If there is nothing like that, then of course the verdict, the award by the arbitrators should be respected, honored, and implemented. That is the message to the government. Now, I would like to now delve into some aspects about the situation so far as arbitration in India is concerned, particularly because this CADR, that is your institution, is a research center that was founded and established in 2015. The center is wholly devoted to the Institute's research in matters of arbitration, and it wishes to continue the excellence and enhance the professionalism by promoting alternate dispute resolution in the country. I straight away invite you to certain statistics. In India, we had, before the pandemic came in, we had nearly 3.5 crore cases pending all over the country. Attempts were being made how to reduce the number because total elimination of these is not possible. But those attempts failed, and the pandemic contributed, you see, to the non-implementation of the steps which were in the pipeline. During the pandemic, the pendency has gone up to nearly 4.5 crore cases pending as of today. 4.5. Now, is litigation the answer? It is obvious that litigation cannot be the answer. Cases filed by someone now, possibly the next generation would see the outcome of those cases. They take time. The pendency keeps on increasing, and it is not just in Supreme Court and High Court, but the huge pendency is in the district courts. District courts, you see, where about 98% of the legal profession, they practice law. And 2% only practice in big cities like Delhi, Bombay, Ahmedabad, and Kolkata, Chennai, Bangalore, and all that. The pendency is huge there. So people thought, and the government thought, that arbitration could be the way out as an effective alternate dispute resolution mechanism. But I feel very disappointed in sharing my view that arbitration has again failed to take off in this country. Arbitration has become as expensive, possibly more expensive than litigation. And despite the amendments being made of 12 months and then up to 18 months, the awards are not forthcoming, the proceedings are not over, and that is also due to the court's intervention in the arbitral process, in the arbitral procedures. So the delays keep on happening even in arbitration. Plus, there is the uncertainty that even after the award is given under Section 34, then Section 37, and all, you see, the awards can be challenged. And that challenge in the courts also takes a lot of time. So I think it is fair for me to assume that arbitration has not taken off. And one primary reason for that is also lack of good institutional arbitration in this country. We do not have institutes, you see, like the London Court of International Arbitration or Singapore International Arbitration Center or the Dubai Center or the ICC in Paris, you see, and similarly in the US. We do not have any institution. Some small beginning has been made in Mumbai, in the Mumbai International Arbitration Center, which has been set up, but it's a very small center. What needs to be done is to have very good institutions of arbitration in India, which inspire confidence among the parties which are in dispute, so that they can take up, the institutions can take up these matters. Now, if arbitration is also not an effective alternate dispute resolution, then where do we go? I think we have to go for mediation. In this period, during this event is taking place, you see, in Gujarat. Gujarat is the birthplace of our father of the nation, Mahatma Gandhi, whose birth anniversary birth, 150 years of his birth we celebrated about a year ago, 150 years. And going through his writings and everything and what he had to say, it's very important for young students also and the faculty members to note what our father of nation had to say about resolving disputes. He advocated that we should adopt, adhere to, and act upon certain principles which he had taken out, culled out, you see, from the Bhagavad Gita. In this context, he said, I would ask myself question, why should dispute arise, and particularly disputes which need to be decided by courts or by arbitrators? He said, if we follow ethics in business, there may not be any disputes. Gandhiji once mentioned that all business entrepreneurs should ask themselves the question. And what was the question? Question was whether their activities are morally, ethically, and legally correct. The statement emphasizes the importance of nobility of business purpose. The father of nation also mentioned that all businesses have a social responsibility, which includes prevention of disputes. This is what he highlighted, which includes prevention of disputes. And if disputes do arise, then to settle the disputes on basis of moral conscience. On basis of moral conscience, not on basis of law. Now, dispute obviously has two parties, where one party is right and one party is wrong. That is how the disputes arise. If the party which is in the wrong applies the Gandhian principles of ethics and good business moral conscience, it may not lead to a dispute. This is the philosophical approach, you see, what the father of the nation highlighted, that you should try to settle the disputes. And this is very aptly captured, you see, in one famous judgment in United Kingdom, where they say a bad settlement is better than successful litigation. This is a very important, you see, theme which I think should be addressed. A bad settlement is better than successful litigation for obvious reasons. Settlement involves some give and take. Very well. One party says, you owe me 1 million. Very well. You give me 500,000. I'll be happy. Other party says, rather than spending on lawyers and the courts or the arbitrators, we'll try to settle the matters. That is the approach. Now, that is where the mediation comes in. Mediation can play a very important and significant role. And it is being promoted by even voluntary organizations in India and even by the courts. Various high courts have set up mediation centers, and they are doing a great job. Now, mediation is obviously, but you need trained mediators. Everyone can't be a good mediator. Lawyers may not be good mediators. Judges may not be good mediators. They know more about the technicalities of law rather than, you see, on skills of being a good mediator. Therefore, what is required is skill development to train mediators. And that is where institutions like the bar associations or the law firms and more importantly, you see, the centers like the universities, like you can introduce, you see, some topics, how to enhance the skills to negotiate. There can be a stage before mediation, that is negotiation among the parties on an informal basis. Generally, big corporations, they have in-house counsel, general counsel, and all that. So if they are trained to negotiate with their counterparts in the other on the other side, that may also lead, you see, to settlement of differences, because they have still not been converted into disputes. So these differences can be sorted out by having a skilled negotiation among the parties. So I would strongly urge, you see, that I've been doing so in other law schools also, that please try to, particularly the final year or fourth and fifth year students, to have some, you may not introduce it as a subject or a topic, but some sort of a informal uh, media system, you see, to inform them how to develop their negotiating skills, so that differences don't become a dispute. And if at all they become disputes, then those should be settled by mediation, for which you need skilled mediators. Where that is where the role of the Chartered Institute of Arbitrators comes in, which has a very effective training programs, not only for the arbitrators but also for the mediators. So these are my remarks about the scenario which exists in India in the field of alternate dispute resolution. And my impression is that we have not been able to find any alternative to the dispute resolution, despite so many attempts being made to amend our laws. It is not amendment of laws which is important, it is change of your mindset. And that change of mindset has to first come from the government. Government should respect, you see, the verdicts which are given against the government, and not just keep on challenging those, you see. That sends a wrong signal, a wrong message to the country as a whole and to the international community of business also. So I thank your institute. I thank Professor Purvi Pokhriyal and all the faculty members and the moderators. And it has been an honor for me to have shared this platform with Professor Kaj Hober. Uh, so thanks and all, and good wishes to all of you. Thank you.
Thank you so much, Mr. Bhasin, for such a careful overview in such a short time. It is indeed overwhelming to hear the backlog of the cases and how arbitration has proved a disappointing in solving the problem it was developed to solve in the very first place. Thank you for highlighting the void and how it could be possibly filled, and also how mediation could be a way ahead. Thank you again. And I would now like to invite Professor Kai Hober to address the gathering on the topic of investment arbitration. Professor Hober, please.
Thank you very much. I don't know, can you see me? I can't see myself on the screen any longer, but can you see me?
Yes, sir, we can absolutely see.
Okay. Let me see if I can. Okay, I can see you, Nikita, but I can't see myself. But okay, never mind.
I hope it's pleasant, sir.
Yeah, absolutely. A great honor and pleasure for me to be with you today, even though it's in remote mode. I'm thankful for the invitation to participate in this meeting, in particular to Dean Pokhriyal and Nikita, and of course it's a pleasure to meet my colleague Professor Bhasin today. I hope sometime to be able to visit physically India and your university and law school. I've been asked to say a few words today about one aspect of investment treaty arbitration, or rather two, i.e. the role of national courts in this system, and the possibility of having a so-called appeals mechanism with respect to investment treaty arbitration. As many of you know, there has been a virtual explosion or boom of investment treaty arbitrations during the last 20 years or so. It really started at the end or mid-90s, I would say, And all these disputes are based on investment protection treaties, be they bilateral or multilateral. As far as bilateral treaties are concerned, we have, I think, still probably around 3,000 or so. And as the name indicates, it's bilateral, it's entered into between two governments. There are several multilateral treaties. NAFTA, also in its new form, I think, has to count as one of the multilateral ones. We have the Energy Charter Treaty, which is quite important from a European perspective, dealing with arbitration or investment arbitration in the energy sector. And there are other regional multilateral treaties as well. Almost all of these treaties have arbitration clauses, which means that an investor that is of the view that the government has done bad things to his investment, he can take the host state to international arbitration. And that is what we see is happening now in a big way, I think, all over the place. These arbitrations fall largely into two main categories. One category is the ICSID system. Arbitrations that are being conducted based on the ICSID convention have as one of the important features that you cannot go to local or national courts at all. It's a completely self-contained system. The other important aspect, and which is usually viewed as an advantage, a big advantage with the ICSID system, is that under the ICSID convention, every award is automatically enforceable in the ICSID member state. So when we talk about ICSID arbitration, there is no role at all for national courts, supposedly. I may come back to some of the complications later on, but generally speaking, it's intended to be a self-contained system. But it is also within the context of reform discussions concerning ICSID that commentators have started to talk about a possible appeals mechanism. And I will come back to that later on. But I will start out with discussing the role of national courts. And it follows from what I just said that national courts fall or belong to the other category of arbitration, i.e. non-ICSID arbitrations, non-ICSID investment treaty arbitrations. And these arbitrations are basically conducted applying, if you will, a national legal system as far as the arbitration procedure is concerned. So if an investment treaty arbitration takes place, let's say in Stockholm, or in Paris, or in London, or in Geneva, the arbitration procedure as such is, strictly speaking, governed by national law. As you probably know, the substance of such disputes, the merits, are always governed by public international law. But as far as the procedure is concerned, national law comes into play. So if an award, let's say an investment award is rendered, let me take Stockholm as the example again, is rendered in Stockholm, and if the losing party wants to challenge the award, i.e. seek annulment of the award, he must do that in national courts, i.e. in the courts of Sweden, and in particular in Stockholm. And the same basic rule applies throughout the world, i.e. if you have a non-ICSID arbitration and you want to challenge the award, you have to go to national courts. In almost all jurisdictions, there is no separate legislation dealing with challenges of investment treaty awards, which means that the award in question, the alleged or the requested annulment of that award, will be decided based on national arbitration legislation. As you probably know, in most jurisdictions, the grounds on which an award can be set aside are very narrowly defined. It's usually formal procedural shortcomings, so to speak, that can lead to the setting aside of the award. And you have to distinguish between setting aside the award, challenging the award, and appealing the award. So in these annulment proceedings, you can never have a court of law retry the merits of the case. So the resulting decision from a national court is always a binary one. Either the award is set aside or it stands. If it is set aside, it is up to the parties, if they so wish, to start a new arbitration. And that has indeed happened, but it doesn't happen very often because, as Professor Bhasin indicated, I mean, arbitration is now quite an expensive exercise. But going back to the annulment situation, it is then for the court, and let's say the Swedish court, to decide whether or not this particular investment treaty award is to be set aside or not. Most of the grounds for setting aside an award are, from this perspective, not necessarily very complicated. It's about due process to a large extent. But there is one annulment ground which does raise certain questions when we talk about investment treaty arbitration. And that is the ground according to which an award must be set aside if there was no arbitration agreement. As you know, every arbitration is based on the idea that the parties agree on arbitration. And if there was no such agreement on arbitration, the award must be set aside. Now, in the traditional commercial context, the situation is that you have typically an arbitration clause in a contract. And there may be issues with respect to the scope of application of that arbitration clause, or whether or not it is, for other reasons, valid or invalid. In investment treaty arbitration, the situation is different, because when the arbitration is started by the claimant, at that point in time, there is no arbitration agreement. So the mechanism is such that when the claimant files his request for arbitration, which is sent then to the respondent or to an arbitration institution, that request constitutes the claimant's acceptance of the standing offer of the host state to go to arbitration. So it's only at that point that you have an arbitration agreement. There are many disputes, not only in courts, but also before tribunals, as to whether or not the claimant's acceptance corresponds to the standing offer that you find in the arbitration clause in the treaty. So for a Swedish court, in my example, then, to determine whether or not there has been a valid arbitration agreement, they must actually interpret, very often in these situations, interpret the arbitration clause in the treaty. An interpretation of investment protection treaties is to be done based on the Vienna Convention on the Law of Treaties, i.e., this is a matter of public international law. So many courts in many countries, including Sweden, I think, find it a bit awkward to all of a sudden, so to speak, have to decide a question based on public international law, because that's not what they do on a daily basis. And we have seen examples of national courts, including in Sweden, approaching this interpretation exercise in perhaps not an optimal way. By that I mean they have looked at the arbitration clause in the treaty as if it were an arbitration clause in the contract, and typically used, contract interpretation principles in interpreting the arbitration clause in the investment treaty. They have learned their lesson, I think, over the years, and are now becoming more and more sophisticated in dealing with this. But this is one, I think, still somewhat problematic aspect of national courts, of the role of national courts in investment treaty arbitration. And therefore, voices have been raised, or questions have been raised, as to whether or not this is really the best way of dealing with these matters. These ideas, these comments have also led to a discussion about the viability or the desirability of creating a new sort of international court for investment treaty disputes that would deal with all issues concerning investment disputes. I have to say, speaking for myself, I think that is a somewhat unrealistic hope, at least for the foreseeable future. So I think the best way to deal with this potential problem, and sometimes real problem, is to try to educate judges in different countries as to what they have to do when they're faced with interpretation of international treaties. Otherwise, apart from the annulment proceedings in an investment treaty arbitration, the role of national courts is very limited in most jurisdictions. India might be an exception, I don't know. I have no experience of that, but certainly if we talk about my country and in Europe generally, there is no role for national courts in international arbitration, including investment arbitration. They cannot interfere with the arbitration. They cannot stop the arbitration. Sometimes they have assisting function in the sense that, for example, if one party has not appointed an arbitrator, the respondent usually, in most legal systems, you can go to a national court to ask the court to appoint an arbitrator for that party. So apart from annulments, there is really a very limited role for national courts. I should also say that with respect to these non-ICSID arbitrations, they are usually conducted on the basis of ad hoc arbitration rules or institutional rules. The UNCITRAL rules of international commercial arbitration from 1976, as amended, they are often used in these disputes, or the arbitration rules of the Stockholm Chamber of Commerce, the SEC rules, or the ICC rules, the rules of the International Chamber of Commerce in Paris. And all these rules have mechanisms for example, appointing arbitrators if one party has not done so, and also for trying challenges of arbitrators, for bias and so on and so forth. So that is, in short, the role of national courts in investment treaty arbitration. Let me then say a few words about a possible appeals mechanism with respect to investment treaty arbitration. As some of you probably know, this has been a topic for quite a number of years now. And indeed, the investment treaty arbitration system, as it's sometimes referred to, has been criticized in several respects. And one of the criticisms has led to suggestions that there has to be or should be an appeals mechanism. And the criticism in question leading to this suggestion is that some commentators say there is no consistency in investment treaty awards. I mean, one tribunal says X, another one says Y, even though the cases are very similar, or perhaps it's said that they're even identical. So we need to have a mechanism which creates some sort of case law in investment treaty world, which creates some degree of predictability. So that has been the basis for these suggestions. To a large extent, in my view, this criticism is based on a lack of understanding of how public international law works and of how international arbitration works. As I've said, I mean, these treaties are all creatures of public international law. And as you probably know, public international is a very non-hierarchical system, a very flat legal system. I mean, you have no Supreme Court, you have no international court. We have one international court, true, in The Hague, but it doesn't have worldwide jurisdiction. It's based on consent, basically. You have no legislature and so on and so forth. Public international is based on the idea of the equality of all states, the sovereignty of all states, which means you cannot basically do anything under public international unless you have the consent of the states involved. So those are the basic principles of public international law. And these principles lead to the conclusion that no arbitral award, no tribunal can issue awards which are binding on any other parties than the parties to that particular dispute. No tribunal can bind another tribunal. So it's a very, as I said, horizontal, non-hierarchical system, flat system. This doesn't mean, of course, that a tribunal faced with a particular problem will not take into account what other tribunals may have said on that issue. But it's certainly not bound to follow the conclusions or the reasoning of that other tribunal. So I think this is important to keep in mind, that there is no stare decisis principle, no binding precedent principle in international law and international arbitration. And it's true that some decisions, some awards seem to point in different directions concerning similar issues. But I think it's important to keep in mind that, as an arbitrator, your task, your duty is to deal with and resolve and decide the issue that is put before you. And you do that based on the arguments presented by the parties, the evidence presented by the parties, and the facts presented by the parties. So even though many disputes may look identical, or at least similar, they very seldom are. So one has to be, in my view, perhaps a bit cautious in criticizing tribunals having reached different conclusions on facts which to some commentators may seem to be similar. So I think it's not surprising, quite frankly, that we have the situation that tribunals come to different conclusions. I mean, this is inherent, I think, in any adjudicated activity, you know, that every case is different, which means that the outcomes also may be different. But this, anyway, has led some commentators to say that we need an appeals mechanism. We need the parties to have the possibility to have issues tried again by another level of arbitrators or some sort of institution. It's unclear what exactly some of them have in mind. But in the discussions, well, several years ago already, the ICSID tried to, was suggested anyway, one form of appeals mechanism, which was at that point rejected, I would say, by the arbitration community. And there are discussions now within the UNSTRAL Arbitration Working Group and other fora to maybe introduce some sort of appeals mechanism. And there are, of course, different possibilities here. You could have, as an appeals mechanism, another tribunal, an appeals tribunal, which would be then, I mean, an ad hoc tribunal. Then you would have, again, questions about who is to appoint them and so on and so forth. Or you could have some sort of a permanent body. Again, the idea of having an international court on investment arbitration, a permanent body trying these issues. So there are several possibilities. All of them, I would say, have their own problems of different kinds. I think for me, I mean, or one basic question, perhaps the basic question, is that, well, how do we guarantee that the appeals people will get it right? You know, they may also get it wrong. I mean, if the feeling is that the first tribunal has not come to the right conclusion, what is the guarantee that an appeals mechanism will do any better? And again, without agreement, the decision of the appeals body, at least following traditional public international, will not be binding on any other parties than those to that particular dispute. So it's probably not an automatic solution to the perceived problem of tribunals going in different directions. That may still be the problem. And you also have the more fundamental problem, perhaps, that one of the cornerstones of arbitration, international and national, is the idea that it's supposed to be one-stop shopping, i.e., you have one bite at the apple and that's it, which means that arbitration is typically quicker and cheaper, for example, than going to court. If one were to introduce an appeals mechanism, it would be obviously take much longer and resemble some sort of court proceedings again. So there are a number of problems, I think, related to this idea of having an appeals mechanism. And also, how is the appeals mechanism going to interact with the rules, the possibility to have an award annulled? Because an appeals mechanism would actually mean that you can have the award retried on the merits, as opposed to in the annulment situation where it's only, as I said before, it can be set aside only based on procedural and formal grounds. So there are a lot of question marks surrounding this idea of having an appeals mechanism. Speaking for myself, I think that the best way, of creating predictability and coherence as far as international investment law is concerned, is the old traditional way of creating, case law, if we call it that, i.e. awards which are being analyzed and discussed by scholars, which will in turn influence the decision makers and so on and so forth, i.e. rather traditional development of arbitration jurisprudence in this area. But as many of you know, discussions are going on, as I mentioned before, in the Untitled Arbitration Working Group and in other fora, so we will have to wait and see what will happen. I think I will stop there, and I will be happy to answer questions or respond to comments if there are any. Thank you very much.
Thank you, sir, for giving your valuable insights on such a contemporary topic. We have 3 questions, 2 from one of our student, that is Shalini Mishra. She is asking, can the national courts of the investor or the national court of the host state interfere when there's concurrent jurisdiction over a specific case in ISDS?
I'm not sure I understand the question, but the short answer is no. There is a discussion that some of you may be familiar with concerning the distinction between treaty claims and contract claims. So if an investor files an arbitration under an investment protection treaty, arguing that the host state has violated the treaty and asking for compensation for that violation, that is a treaty claim. And no national court can interfere in that proceeding. However, very often you have a situation where the investor has also, as part of his investment, established a local company in the host state. And that local company may have contracts or permits, approvals, or whatever granted by local authorities. And that local company may then also bring a claim in local courts concerning factual matters which overlap with the treaty claims. And that under certain circumstances, it may be possible, not really for a national court. I mean, those cases may in fact go forward in parallel as a matter of principle. But in most investment treaties, you have a clause which we refer to as the fork in the road clause, which means that the investor must choose to take his dispute either to arbitration or to local courts. So, and I mean, I can develop the details further if you're interested, but this is usually a rather complicated legal issue as to whether or not the case pending before the local courts and the case pending before the tribunal is the same case or not. But as I said, the short answer is the national courts cannot interfere. Does that answer the question?
Yes, sir, indeed it does. The next question is that what if, this is a question from one of my faculty colleague, Ms. Surekha Talari. She's asking that what if the government itself is a party in dispute with the other party, let's say for example, a multinational agency, then how is arbitration conducted? Her question is that if a government has any kind of a contract with another multinational agency situated in some other state.
Yeah, okay.
In that circumstances, how does arbitration work? Because there is one state party involved and the other one is a multinational company located in some other state.
Yeah. No, I mean that's how it works. In these investment arbitrations, the respondent is always a state, and the claimant is always an investor, which is either a company or an individual. And so the basic concept here is that if the state has done things to the investment, then which are allegedly in violation of the Investment Protection Treaty, the investor may take the state to arbitration under the treaty. And the same applies basically if the state itself is a contracting party with the investor. If the state does not, let's say, or if the state terminates the contract in the view of the investor, then usually unlawfully, that can also be an arbitration conducted, an investment arbitration. And in these investment treaties, the arbitration clauses look, well, more or less the same in the sense that the investor has the choice between different forms of arbitration. Usually ICSID is one option, or UNCITRAL arbitration rules, or in the case of the Energy Charter Treaty, for example, the Stockholm Chamber of Commerce. So there are different forms of arbitration that are made available, so to speak, to the investor. And depending on what form the investor chooses, then that's how the arbitration will be conducted. So there's no, these treaties are by their nature quite one-sided, in the sense that the respondent is always the state, and the respondent can usually not, in these proceedings, file counterclaims. So it's all about the investor choosing the form of arbitration and the investor having his claims directed against the state tried by this tribunal.
So I have a question at my end.
Please.
The situation becomes a bit simpler when we talk about bilateral investment treaties, because there are only two parties involved in that particular situation. But how does this particular scenario govern the multilateral investment treaties, where there are more than two states or two parties involved as a party to the same treaty? In that situation, if a dispute arises between, let's say, two states, and both of those states decide to go for arbitration. So in that scenario, how do the arbitrators ensure that the award that they are going to pass for resolving that particular dispute between the two states would not have an impact on the third or the fourth state, which are a party to the same investment treaty? Because again, there would be certain kind of an impact if there is some changes being made to the treaty for resolving their dispute, or any other award that this arbitrator passes.
Well, I think it's not as complicated as it might seem, because quite seldom you have multi-party arbitrations in as far as investment arbitrations are concerned. You're usually dealing with one claimant or group of claimants against one respondent. And as always, the resulting award is only binding on the parties to that dispute. So whatever the tribunal says has no bearing on anything else under the treaty or on anyone else except those parties. And of course, the tribunal cannot amend or change the multilateral treaty in question. That can only be done by the parties to that treaty, and usually done only on the basis of a qualified majority. So under the ECT, for example, if there is an award rendered between company A from Finland and the state of Germany, let's say, that award is only binding on those two parties and has no effects, no consequences for the Energy Charter Treaty as a treaty. Does that answer your question?
Yes, indeed. We have 2 more questions,
Sure.
if the time permits. Yeah.
Sure.
So the question is from our student Samyak Jain. He's asking, can we call review appellate body or multilateral investment court a politically viable option, as European Union and United Nations discuss on this topic from quite some time? And his second question is, sir, don't you think that the issue regarding review mechanism is necessary in light of impartiality and independence of arbitrator in investment arbitration cases?
Let's start with the first question then. I mean, is it politically viable, the review mechanism?
Yes, so that's the
well, it
question.
remains to be seen, I think, because there are, as I try to illustrate, there are many. If you want some form of a review mechanism, I mean, you can do that in many different ways, and depending on what option you take, it might be politically viable or not. But either way, it will require. Well, certainly, if you're going to introduce a review mechanism, which is based on some sort of a treaty, obviously you need the consent of. You need to convince others that this is a good idea. You need to convince other states to sign up for this treaty. And to what extent that is politically viable or not, again, I think also depends on what that treaty would actually say. I mean, let's assume you want to create an international investment court. Well, I mean, is that realistic? Who will sign up to this agreement? Who will appoint this court? And how do you deal with bias and impartiality, independence? If you've been on that court and decided one case in one way, or you then partial the next time the same issue comes up? So there are a lot of detailed questions you need to solve in an acceptable way before you can present, I think, or introduce a review mechanism that would work from a legal perspective. So, I mean, a lot of commentators are having a lot of ideas about this, but at the end of the day, I think it will not happen within the foreseeable future. And the other question, could you repeat that, please?
So you have answered both the questions.
Okay.
Because his second question was related to on your views regarding the review mechanism, whether if it is necessary in the light of determining the impartiality and the independence of arbitrator in investment arbitration cases. So his question was that whether the review mechanism can be for the issue of determining the impartiality and independence of the prior arbitrator who was appointed at the initiation of the arbitration process.
Well, I mean, the review mechanism, the reason why these proposals have been put forward, I think, has rather to do with the merits of the case, because there is a view, as I mentioned, that arbitrary awards are pointing in many different directions, even though the facts seem to be similar or sometimes allegedly identical, and we need some predictability here. So the review mechanism, I think, those discussions have focused on how to create a predictable, case law, sort of, and not so much on dealing with the impartiality and independence of arbitrators, because there are already mechanisms in place. I mean, in the Isds system, for example, you can challenge an arbitrator, and that will be decided then within the Isds system by something called the Administrative Council of the World Bank. And if you go to non-Isds national arbitration, I mean, most arbitration institutions like the ICC, the SEC and LCA in London, they have in their rules mechanisms for challenging arbitrators and for ruling on those challenges. And and most national legislations also have in their the possibility to go to court to have those issues tried. So I think the perceived need for a review mechanism has been focusing on on the merits rather than on impartiality and independence of arbitrators. But of course, you have, I mean, if you, the question, of course, is that if you're going to have an appeals mechanism, who can sit at the appeals level? I mean, if you've been involved in a case that is similar, or where similar issues have come up, can you still sit in appeal on that? If the answer is no, I mean, we'll soon run out of arbitrators, because I mean, you can only the rule on one issue once and then you're out. Just to mention one problematic aspect, perhaps, of the review mechanism.
Thank you so much, sir. So now I take this opportunity to express my heartfelt gratitude to Professor Kai Hober for accepting our kind invitation and also sparing time from your busy schedule to share your knowledge and experience and expertise on the subject of investment arbitration and the role of domestic courts in the same. And now I would also like to thank Professor Dr. Purvi Pokhriyal, because she has always been the back of in planning this particular event, and without her support and constant guidance, this event wouldn't have been there in place. And now I would want to thank the organizing committee, Professor Nikita, our student body, Shalini and Samyak, who have been planning and working day and night to execute the event. And last but not the least, I would thank all the student and the faculty participants for participating actively in the interaction. And I am very sure that we have actually benefited from the expertise of Professor Kai Hober and the knowledge that he has shared with us, and hope to host you very soon again, sir.
Thank you very much.
Thank you so much, Professor.
Thank you.
Thank you.
Thank you.
Hopefully, we will see you very soon. Thank you, sir.
Thank you. Bye-bye. Bye.
Bye.
Thank you.